Welcome everyone to the October, almost November version of the Lunchtime webinar series. Today we're going to be talking about independent contractors. Today we have what it looks like Fred Marcinak, but it says Rob Moseley and Lesesne. Rob is unfortunately at a status conference for a trial, and so Fred's pitch hitting here for him. But as we normally start, we're going to start with the national days, but yeah, we all know today's Halloween. So I hope everybody goes out and has fun and gets lots of candy. But going along with Halloween, it's amazing that today is actually National Doorbell Day too. I guess because a lot of doorbells get rung on Halloween. Bread Stick Day as well, National Magic Day, and actually also National Knock Knock Joke Day. So I decided to see what ChatGPT would give me for knock knock jokes having to do with the transportation industry. So here are three that ChatGPT came up with us for us. Knock knock. Who's there? 1099. 1099 who? 1099 pages of discovery proving he's totally independent except for Qualcomm, fuel cards, dispatch times, and safety manual. So knock knock.
Only the folks on this call can appreciate that.
Yes. Knock knock, who's there? Independent who? Independent contractor. I run my own business, use my own truck, and take my own loads, but somehow you're still getting sued for everything I do. And then lastly, knock knock, who's there? Independent who? Independent contractor. Until there's an accident, then apparently I'm management's long lost employee. And that's exactly why we're here today. We're here to talk about the lines between independence and control, making those crystal clear. So I'm going to turn this over to Fred and Lesesne. Thanks, guys.
Yeah, thank you. That's a great introduction, and we glad to be here and happy to present on this topic. We're I think that those jokes definitely set the stage for what we're going to be talking about today. I'll give you the disclaimer that we have to give before every presentation. This is only for educational purposes. It's not legal advice. And by continuing to observe the webinar, you agree that any information is not going to be used against us or our clients in future litigation or claims. So now that we got that out of the way, wanted to talk again. This webinar series is about independent contractors. But along with that, and really, kind of what we're looking at is what's the line between independent contractor and employee. Right here, I wanted to start off with kind of the basics of what we think of as your typical employee or independent contractors. So when we think of employees, we think of factory workers, secretaries, cashiers, and why do we think of them as your typical employees? Well, for a factory worker, they could come into the same place every day. They go to the factory, they clock in and out. They may wear a uniform. Same with secretary or cashier, where they have specific duties that they're performing. They come to the same location every day, clock in and out, or they may have shifts. So when you're thinking of employees, that's who really, for me, come to mind as your typical ones. For independent contractors, think of it as we like to give examples of landscapers and plumbers that can. And when I say that, I don't mean that the landscaping company hires another laborer under their landscaping company. But what I mean by that is you yourself as an individual, you have a house and you need for somebody to come take care of your yard, or you have a plumbing issue. You hire these individuals to come to your house and perform work either in your yard or in on your toilet, and then that's the relationship that you think of as an independent contractor, where they're coming over for a task to be performed, and they're not showing up. The landscaper's not showing up to your yard, and you standing out there with a rake and throw them a rake and say, "All right, let's get to work." So stuff to think about. One of the biggest pitfalls with independent contractors is that, I pay this individual a 1099, so that means they're an independent contractor. It's not that. That's not the answer, and unfortunately, it's not that simple. So today, and you'll see there are four main really issues that we're going to be talking about with independent contractors, and it all has to do with misclassification. So when you hear misclassification, what we're talking about is you have designated this individual as an independent contractor when the law would actually say, no, this person is an employee. And so there are a lot of repercussions that can come from that, and lots of different laws that you could have exposure to if you have a misclassification issue. So we're going to talk about workers' compensation and the kind of how that plays into it. Unemployment, just briefly, we're going to touch on employment taxes, benefits, and labor, and then finally the truth in leasing. That's another thing specifically with the motor carrier industry where it applies. Truth in leasing is specifically regulations that apply to motor carriers. So one, we're going to go over workers' comp claims, the independent contractors and the nature of the transportation industry. So a lot of the issues that motor carriers face in this industry are really can be separate from what a landscaper may have an issue with, or a plumber, if a plumbing company. So they, because of the nature of your industry, any of the drivers that you end up bringing on and hauling under your authority, they could be from anywhere. If you're an interstate motor carrier, you could determine that, okay, well, there's a driver, he lives in Virginia, and he's going to be running loads all throughout the country. And you may be located in South Carolina or Illinois, but you hire that or contract with that individual to start running under your authority, but they're from Virginia. Another issue is that while they're performing this transportation, they can drive through any state. So a lot of these laws, with the exception, a lot of the workers' comp laws and the unemployment issues are state specific. So the issue with having drivers is that they can drive through anywhere, which means they could potentially get hurt anywhere in any state. And so you could be dealing with laws that are not familiar to you, but they end up, the contractor ends up either being from that state or traveling through it and getting hurt. So it's not necessarily going to be where you may be dealing with laws from a state that's not your own. And so that's unique to the transportation industry, that you have to deal with those problems. So starting with defense of workers' comp claims. So I'm going to just briefly touch this. So if you do get hit with a workers' comp claim, some things to really think about immediately when it comes in the door are, you want to first, I'd say, review your logs and make sure, was this driver actually under dispatch at the time of the incident, or was he not actually moving, or was he not under dispatch at the time that he was hurt? Jurisdiction and venue. So we talked about the fact that they can be driving through anywhere, and if they get hurt in a place, they could potentially file a workers' comp claim even if they're passing through a state. If they're not from there, or if you're not from there, they could file it in that state. But it doesn't necessarily mean that you're subject to that state's jurisdiction. So you could have some arguments to defeat that and potentially have either the claimant file in their own state or in the state that you're located in. Finally, the average weekly wage for calculation in a comp claim. So if you've worked with comp, the average weekly wage amount can really dictate how much the benefits are going to be owed. So one thing that if you have a 1099 contractor and you're doing it right, which we'll talk about later on, is that really the 1099 should be you should be paying based on the truck's use, not the individual driver. So ideally, if you have an independent contractor agreement with a contractor, the motor carrier is leasing the truck from that contractor, and so that contractor could potentially have other drivers that they hire to drive the truck. So in that case, the 1099 may not be the most accurate way to determine the average weekly wage for the benefits. So those are just some kind of brief things to think about when a claim comes in the door. But looking at, and we have a couple of states' laws up here just about the laws to determine whether in the first place this individual is actually an independent contractor or an employee. So in addition to those arguments that we brought up, one of the biggest arguments is, well, is this individual an independent contractor or an employee? And so, the first thing you'll look at is the test. Each state has its own test for workers' comp, so you're going to want to look at the state that you're actually in and where the claim is being filed.
Yeah, and if I can jump
yeah.
in there, was saying, yeah, and so, if we're talking about a situation where you have I'm just going to say a truck driver because that's what we mostly see, but a truck driver who's been injured and we think he's an independent contractor, but he files a claim against us and says he's entitled to workers' comp. Some states there's a test, and they're going to go through and say, does he qualify as an employee under these tests? And that's what Lesesne's talking about. And then there's another category of states where either by law, usually by a statute or by a judicial decision, they have said it really doesn't matter how this test would end up. We're always going to consider that person to be an employee, or they've applied the test, and 100% of the time they've always found the person to be an employee. So there's a handful of states Lesesne's going to talk about in a few minutes where it's just pretty much automatic that a truck driver can get workers' comp. So if you're on that category, you're outside the test. You're just kind of predetermined. But in some states, like Lesesne's talking about here, you're still within the test. So that's kind of the first division point, and then you go through the test.
Yeah, absolutely. So, that's important, and it's important to identify that quickly, and determine, okay, what are we dealing with? What kind of state are we working with, and what type of test do they apply? Because it could really dictate what you end up doing from there. So, South Carolina, this is the workers' comp. This is the control test for comp claims, and this is applied to every any type of comp claim, regardless of whether it's a driver or not. They look at these 4 categories: the exercise of control, the furnishing of equipment, the right to fire, and the method of payment. Each of these a lot of these are fairly self-explanatory. The biggest thing with the right to fire is, if it looks like an at-will employment where, you can just terminate this individual for any reason or no reason, that's going to be different, because when independent contractors, they're subject to a contract. So if you want to get rid or if you want to terminate that contract, there needs to be a provision in the contract, either that they've breached or something like that you need to be able to, that allows you to terminate that relationship. So those are the elements that they look at to see what, for any type of independent contractor. Now, South Carolina has a very specific law that actually can help, and there are other states like this that have specific laws that can apply to independent contractors in the motor carrier industry, and particularly it involves a lot of times it involves either a definition or a specific considerations of whether the individual that you've signed on, the motor carrier signed on, is an owner-operator. Now, South Carolina has this specific provision that if the individual that they've hired on is either under a bona fide lease purchase arrangement or an installment purchase agreement for a truck, or if they own the truck outright, and they enter into an agreement with the motor carrier, then this can be this can help with the analysis to say this individual is actually an independent contractor instead of an employee. So this is a really good statute. There are other statutes like it that apply in different states that apply to the motor carrier industry and look at this test and can really help you if you fall under these categories. It can really help.
Yeah, and the issue there is, Lesesne talked about the control tests, and there's a variety of factors. And if we have a driver we want to classify as an independent contractor, we want to meet as many of those factors as we can towards being an IC. But what a lot of times in the trucking industry, what it comes down to is who provides the truck. And Lesesne and I both will talk to folks, and they'll say, yeah, these guys are independent contractors. We pay them on a 1099, but we just put them in a truck and they drive our trucks. It's going to be very hard to win a control test if you supply the truck in the trucking industry. In a perfect world, everybody would be a true owner operator and would come to you with a truck they own or they lease or they they already have. But what we know is that trucks are expensive, and a lot of these guys they want to be a 1099. You want to be a 1099, but they can't afford to buy a truck. And so you say, well, what about if I lease them one of my trucks? Well, what this South Carolina law is saying is if it is a separate leasing company, even if you own it, if it's a separate leasing company, there's a way to get there. There's a way to make that work. A lot of states are similar to that. Now, some states say that's still not good enough. You can't do that. It's a state by state thing, but a lot of states will be like South Carolina. So that's what we're trying to do is say there's a way to provide a truck to someone and still allow that person to be an IC. And so, we work with a lot of folks that come to us and want that solution, and we have to take their existing program and rework it to meet the state law to allow that to work. So, just a good thing to think through.
Absolutely. Yeah. And I mean, it's huge. I know it's a long paragraph, but a big thing about these statutes, and not all of them, but a lot of them, and in here it says this individual is considered an independent contractor and not an employee of the motor carrier under this title. So if you follow this and you read the statute and you can meet these requirements, then you have a really good, you don't have to, it's almost a safe harbor if you can fall under this, because a lot of states, they'll have the underlying assumption, and the test starts off with, we consider them an employee. You have to prove to us that they're an independent contractor. So if you fall under a provision like this, then it can be really beneficial and go a long way. Now we turn to North Carolina, which is a state that has, I'd say, a really different type of law that they have on the books. So it's one of those that's specifically directed at the motor carrier, at the transportation industry and the motor carriers. So I say that, and you think, okay, well, yeah, maybe they helped us out. Well, they didn't. So what they have in the regulations is that every driver has to have workers' compensation coverage. They say that if it doesn't matter if you consider them an independent contractor or an employee, they need to have workers' comp. So that's a pretty difficult statute that essentially it's directed at the motor carrier industry that can be an issue for some carriers, and even we'll get into it some more for a little bit in another section. But even some brokers could have issues with North Carolina law. So we do have attorneys that are licensed in North Carolina. Fred is one of them, and we see a lot of increased enforcement with the North Carolina Industrial Commission, which does the workers' comp. And if there is a comp claim filed by a driver or an individual, it's not. They will look and see, okay, do you have workers' comp on the books with North Carolina? And if you don't, you could be dealing with a comp claim as well as potential penalty.
Yeah, it's I mean, the law in North Carolina just is that you have to have workers' comp coverage for each and every truck driver, and there's no way to get around that. That's just the law. So what do? Um, you know, you can comply with the law and buy workers' comp and have it on each and every driver, and that's a solution. A lot of people do that. That's what the law would require. It's fairly expensive to do that. Some folks on the other end of the spectrum just choose to do nothing. We'll not buy anything. We won't be compliant, and we'll just roll the dice on whether we ever get caught by that. We obviously don't recommend that. And then in the middle, there's solutions involving occupational accident insurance, which is not sufficient to meet the statute. The North Carolina is very clear about that. That doesn't meet the statute. But if you look at an occupational accident with a contingent workers' comp endorsement on it, there are different ways to get there, and insurance agents, insurance brokers out there have developed solutions that can help in that situation. But that's just the law in North Carolina, and I have talked to clients who say there's a man here with a badge and a gun at my door who is handing me a citation for not complying with the statute. So they're pretty serious about it. So you might have people at your door tonight with a badge and a gun who are trick or treating, I guess, but this is real, and that's never fun to have somebody like that show up at your door.
So I'm going to briefly go over this test. An example is California, but it's the ABC test. So some states have this, and this would be, this isn't directed at the motor carrier industry, but if a state has an ABC test where they're determining for comp purposes, the individual, the motor carrier is not going to be able to meet this test, so they're going to be they're going to be considered employees. So if really the biggest part of this ABC test is B and C, worker performs work that's outside the usual course of the hiring entity's business and engaged in an independent trade, you're just not going to be able to meet that. So if you have a state that's an ABC test, that's another one that's just not going to work for you. Here's some bad states for independent contractor relationships. It's where they fall into that category that Fred talked about with laws that, it's just about always those drivers are likely going to be considered employees instead of independent contractors. So it makes you think, whose side are they on? I took this picture. If you can see it, there's a person with a flag of England. Looks like potentially the Irish flag and the Scottish flag, and then the U.S. flag. And my studies from world history, mainly being Mel Gibson movies like The Patriot and Braveheart, tell me that those countries don't always align. But I think the biggest issue with that is that this individual has a Georgia and a Tennessee sticker on their car. So that's probably the most egregious issue that they have there. Some good independent contractor states. So we talked about South Carolina can be good. Again, you still have to, even if you have that a good kind of safe harbor statute in your state, you still need to have a good independent contractor agreement, which we'll talk about later in this presentation. And then you still have to implement it correctly. So here are some examples of ones of different states that have good provisions in there that you can take a look at, and it could potentially be in your favor.
So there's a question on the question is, does the payroll calculation of 66 1/3 of payroll for an independent contractor on the workers' comp policy meet the statute for North Carolina? If you're asking, the answer is yes. If you have a workers' comp policy in force for your company, then it meet and it is on file in North Carolina as your legally required coverage. Then yes, if an independent contractor files a claim, you will be considered to be compliant in North Carolina. So, you know, so for example, if you have a a a workers' comp policy and you buy it because you think, okay, I've got like 5 employees in the office. I've got some, some secretaries. I've got some, you know, HR people, whoever. You got some, okay, so I'm going to buy a workers' comp policy because I legally have to. I'm going to file that to be legally compliant. And then I have independent contractors. Even if I don't think they're covered, if they file a claim, it's going to come under that policy that I've got on file. So yes, that any policy you have that is legally compliant will meet the requirement in North Carolina and will respond if they were to file a claim. So,
So guys,
yeah.
there's a couple other questions that were put in the question and answer. One was, and these two go together, would a motor carrier be insulated from a workers' comp claim if their independent contractor buys a workers' comp ghost policy? And it goes on to say the workers' comp policy covers employees of the business, but excludes the business owner by name. And then a second question, sort of along the same lines, does an independent contractor satisfy North Carolina's requirement for workers' comp if they carry a workers' comp ghost policy?
So the answer is basically yes on both of those. The the I'm sorry, I read that the wrong way. No, um the answer is no on the ghost policy issue. The and remember now that this only becomes an issue if the injured person files a claim. So if I buy a ghost policy and to cover my IC business and I exclude myself as a business owner, I'm essentially saying I don't want to have comp coverage. But the person gets in an accident and then decides, I don't care what I did or what my intentions were, I'm going to file a claim, which actually happens a lot because some companies will have IC sign a so-called waiver of workers' comp. We don't want it, don't charge us for it, we're going to waive it. Those are totally legally unenforceable. But even if they sign that or they buy this ghost policy and they're basically saying, I don't want comp, they get hurt and they go talk to a lawyer, suddenly they're filing a comp claim and saying, wait a minute, I'm an employee or I'm under the North Carolina statute, I'm covered. And those things would not make a difference. They would be entitled to make a comp claim under the motor carrier's policy. And Lesesne kind of touched on it, but if the motor carrier didn't have coverage, didn't have a comp policy for some reason, they could go upstream to the broker and say that they're covered under the broker's policy. So it's a pretty broad exposure that you would have there.
Well, we see everybody, pushing the limits to try to collect, and everybody always, and I'm just jumping in here after walking out of the courthouse. So if you expected to see me before now, I apologize, and if you're disappointed, I apologize for that too. But I'm glad to see that Lesesne's trying to carry the ball with some humor here. So, but one thing I'll jump in on in Texas. Texas has got another world in terms of that stuff. So you can opt out in Texas, and so when Fred's saying those forms, aren't enforceable. Well, in Texas they might be, but most places they're not. So that's one thing. As to the ghost policy question, North Carolina, the Industrial Commission used to have a memo that they took down from their website, but it used to say they had a memo online that the commissioners had issued that said ghost policies specifically are not acceptable. But they took that down, and so leaving the argument that maybe it would work, but I think, like Fred said, I think that's probably the right answer. And when carriers are talking to us, they're always saying, "Oh, well, Joe would never do that." But the thing is, when there's a workers' comp claim, a lot of times you're not talking to Joe, you're talking to Joe's personal representative, his estate after an accident. So it's not Joe, it's Joe's, kids and wife that are scrambling to try to figure out a way to support their family. So, don't hold on too tight to the personalities involved, because that can really that can really change quickly. So, anyway, take it away, Lesesne.
Yeah. No, so some related issues we kind of touched on it throughout this presentation, but we talked about occupational accident. I think we touched a little bit on contingent comp, so a companion policy to occupational accident. So if they do file a comp claim, could potentially come in to help with defense costs for a claim for you to defend it. Workers' comp audits. So, if you have a workers' compensation policy, at the end of that policy, your insurer is going to perform an audit to see if the risks that they wrote or they estimated are the real risks that they charged your premium based on. So sometimes if maybe there's not good paperwork, or if they find additional risks, you could be looking at a bill from your insurance company assessing you additional premium. And that's one that we've seen, and I will talk about broker audits, but we've seen some where some insurance companies looking at brokers as well, and potentially saying that a motor carrier and the drivers of the motor carrier could be a risk on their workers' comp policy.
Yeah, and Lesesne, that's a great point. On that issue, we see that where brokers get audited, and we're talking about freight brokers. When freight brokers get audited, we see that a lot when the agent, the insurance broker, places that risk with the state fund, or with an insurer that's just a generalized workers' comp insurer and doesn't have any knowledge of the brokerage, the freight broker industry. And so, if you have a brokerage and you're listening to this, you need to make sure that your workers' comp is with somebody that knows what a freight broker is, so you don't face that risk.
We got a question that comes up a lot, a jurisdictional question. Someone asked if I'm a Virginia motor carrier and I lease on a contractor who resides in North Carolina, which state law applies? What if the lease agreement states that Virginia law applies? The lease agreement can't determine the jurisdiction of the workers' comp law. So the lease agreement can can do some other things, but the North Carolina, what they're going to look at is the location of the injury. So this is the bad one. I mean, you could be a Wisconsin motor carrier shipping customer freight from, Ohio to Florida. And if a driver gets injured in the state of North Carolina, there's jurisdiction in North Carolina. Secondly, the employer's principal place of business. So in your example, that would not be in North Carolina. Thirdly, where the employment contract was entered into or was made, that's where. So the short answer is where the contractor lives is not technically a basis for jurisdiction. Now, what they would argue is, well, two things: where the employment contract was made. So, you want to have the driver come to your office in Virginia, sign the contract there. But the other thing is the worker's principal place of business can be a basis. So, what would happen is the IC would argue, well, I work out of my house. I get dispatched out of my house. That's where I begin my duty day. That's my principal place of business. So, you'd have to get around that. But those are the basis to get jurisdiction. So it's where the worker lives is technically not correct. Although if they're going to argue that's their where they report for work every day, that could change that.
And where all the workers' comp systems have a jurisdictional requirement, and so you may have to have 4 contractors or employees in a particular state. to be subject to jurisdiction there. So there are arguments you can make, but a lot of times the commission is very jealous of their jurisdiction, and they'll do anything they can to have jurisdiction over a particular injury. But there are arguments you can make that, if your company has no connection whatsoever with this state, other than this driver was passing through when he had an injury, that could be a jurisdictional argument to say that the commission doesn't have jurisdiction over you in that location. So don't give up on that.
So we're going to skip through these last two slides. These are just more for the lawyers in the crowd. Here's some case law. There's some case law for y'all to take a look at on workers' comp. The second issue that wanted to touch on is unemployment. We'll just briefly touch on it. Again, what you want to look at is look at the statute as far as to determine whether this individual is an independent contractor or an employee. It's not necessarily always going to be the same as the workers' comp statute. Some states do have where it says, refer to this statute, but sometimes they may have a totally different test for whether this individual should be an independent contractor or an employee as far as unemployment tax. Where this can come up is obviously if you terminate the driver or terminate their contract, they file for unemployment, and you could, be them seeking unemployment from you, and then that kind of can get the state to kind of look more into it. If they file an unemployment claim with the state, that kind of is going to could potentially raise some eyebrows with the state, and then you could be looking at an audit from whatever state they filed an unemployment in. So as you can see, there's things can get upside down pretty quickly, where just as evidenced by this Jeep. So it's not a problem until you're upside down. Talking about employment taxes and benefits and labor, just briefly. So the Fair Labor Standards Act.
Well, Lesesne, let me jump in for a second. And one thing that this illustrates is that if you're running independent contractors, you might have 150 different tests that could apply to you that you have to comply with, that you have to meet to stay out of trouble with independent contractors. Because we've talked about workers' comp. That's a different test in 48 states. And he just mentioned unemployment. That's another 48 different tests. And now we're getting into Fair Labor Standards and some employment issues. And you've got state issues, you've got federal issues. You may have another 100 tests you have to meet. So, but then they're all different. Until it hits your desk, you don't really know you have a problem. But Lesesne, go ahead, take us through Fair Labor Standards.
No, that is absolutely. I mean, and so this is, we talked about state, like Rob just talked about state issues. Now this is the Fair Labor Standards Act is a federal law, and so it's gonna. And I'll tell you that really where this would apply is overtime and minimum wage. That's what Fair Labor Standards. There's some additional reporting requirements and stuff like that, but really that's what Fair Labor Standards looks at. This test has kind of gone back and forth between the presidencies. I think Obama had a particular type standard that was used, and then I believe that the Trump administration enacted one standard, and then I think we're now with the economic reality factors test, which uses these factors that looks these 6 different factors to look at, and looks at the relationship, looking at the relationship between this driver and the company, and then just all of these different factors go into play. Like I said, FLSA mostly has to do with overtime. So one thing where the FLSA may not be as big of an issue for you is that with overtime, if you're these drivers could potentially be exempt under the Motor Carrier Act from overtime requirements. Now, it's a case-by-case basis, and you have to look specifically at the driver and are they actually engaged in interstate transportation, and are they engaged in safety-sensitive functions? So there's you'd have to look at it to determine whether they'd be exempt. Federal minimum wage, you wouldn't have an exemption under that. So sometimes where it could be an issue is the cents per mile. If you're paying a driver cents per mile, maybe they get stuck in traffic and they're sitting there for a long time, but they haven't really gone anywhere. They could, but you just want to make sure that you're meeting federal minimum wage requirements. Here's another federal test right here is the IRS. So for a long time, the IRS used the 20-point test, which just had a number of factors. In fact, some states will still say, we use the IRS test, and it's like, well, that's changed now. So they look at 3 different factors: behavioral, financial, and then the type of relationship to determine whether an individual should be an employee or an independent contractor. So finally, the truth in leasing. This is the last portion of our presentation. Show of hands, who knows that there's actually a regulation, a federal regulation that tells you what provisions have to be in your contractor agreement? And I'm seeing 1, 2. Okay, yeah, not very many. So there, that's and y'all aren't on camera, so that y'all don't have to worry. So there is a requirement. There's a statute that specifically says what has to be in your independent contractor agreement. And if you don't have those provisions, or if you're not following those provisions in the statute, or the regulations, then you could be facing truth in leasing lawsuits. So the Owner Operator Independent Drivers Association, they sometimes will work with these independent contractors to help them bring lawsuits for that. And so you'll see that where they'll get together, and potentially, some of these issues may be small if it's just one driver, but where it can become an issue is if they get together and form a class action. That's where you could potentially see a lot of issues where the agreement that you've been using or the implementation of the agreement hasn't been meeting these standards, and now every contractor that you've signed on, you may have a problem. So some problem areas right here that we see a lot of: forced purchases, insurance purchases, chargebacks, escrow. Escrow is probably the number one thing that we see that is incorrectly implemented with independent contractor programs. We'll talk a little bit about it in a little bit. So is the truth in leasing standards the same in all states? So yes. So I'm sorry if I didn't mention, truth in leasing is actually a federal regulation. So it's a federal requirement that is applied across all the states.
And let's say while we're at it, the FMCSA has an independent contractor committee that's meeting right now to make recommendations for the industry. So we may get some changes depending on how that turns out. So Fred, you were going to say something?
Yeah, 2 quick things. One is this stuff is a big deal. I mean, if you're going to have independent contractors, you got to do it right, because there are lawyers who kind of troll these things and look to get a class action going, which turns what maybe one driver's minor complaint into a company-wide, lawsuit. And, I've had clients that get letters from class action lawyers saying, we think you're breaking the law and so forth. So it is a big deal. We had a question, any recommendations for best practices for IC agreements or contracts? I think Lesesne's about to tell us a lot of stuff about that. And the only recommendation I have to add to that is just Lesesne's going to tell us some stuff, but also just have those reviewed periodically. I mean, that I can't tell you how many folks I see that they send me their IC agreement, and no disrespect, but it looks like something they found on the internet 10 years ago and printed out and have just been filling in the blank ever since then. And those are going to be very difficult. So just have those looked at.
Yeah.
Yeah.
And if your agreement is 5 pages, it probably cannot contain all the things that have to be contained. So keep that in mind. And in this process, and Lesesne's going to hit on the landmines that you can step on, but remember in the big picture that if you're doing a lease purchase or something like that, then you're going to have 2 documents. You're going to have an independent contractor agreement that is between the driver or his company or her company and you, the motor carrier, for bringing that truck into your fleet, putting the DOT number on the side. The lease purchase will be a separate agreement where that person, that driver, that company leases that truck from some entity, and then brings that to you. So there's 2 steps in that process. So if you're missing one of those, you definitely need to look at that.
Absolutely. With this, for the first part, we're going to take a look at the independent contractor agreement. So that's the one where and if pursuant to the statute, what we're talking about with the truth in leasing regulations, and the way that it is written is that the independent contractor is going to be signing on or leasing the truck to the motor carrier entity. So if you're looking at it, that's what that agreement is supposed to look like, is that the independent contractor or the individual is showing up with a truck somehow, either lease to purchase or they own it outright, and they're leasing it on to the motor carrier. So some provisions in here that have to be included are, the receipt by the motor carrier. So you're going to want to have a receipt saying that we received it, and then also a portion in there saying that it was returned to the independent contractor upon termination. It has to state that there's exclusive possession by the motor carrier for purposes of the independent contractor agreement. The term of the lease, it needs to have a term, and then you need to have provisions in there, termination that allows for you to terminate the agreement for cause. We talked about a lot of these tests look at employment, so employee versus independent contractor tests, as whether you have the right to fire this individual. This is the agreement where you look at you want to put provisions in there that if they don't follow it, then you can terminate this agreement, and rely on those provisions instead of just firing them or letting them go if they do something that you for no reason at all. Again, so this is the specific provision, the regulation that governs the truth in leasing. So it's 49 CFR 376.12 or 0.12. I would suggest that you actually take a look at it. It's pretty impressive. You wouldn't think that a regulation would be this specific, but it literally tells you what has to be in this independent contractor agreement. So Fred touched on it. When you're opening up your book to see where these agreements came from that you're using, look and see where it came from and when was it written, and to see if you can provide any updates. Some other provisions that have to be in here, for drivers, you're going to want to have medical and drug and alcohol, the equipment inspections and periodic maintenance reports. here are some provisions that we typically see in dealing with passengers. How are you going to deal with passengers for this truck? And then compensation. So compensation is a big one that can really trip people up. Is that you're going to want to specifically let or define how these individuals or really the contractor is going to get paid. Are they going to be paid a percentage of line haul revenue? And you want to write that out and make sure it's known to both parties. And then if you're going to make deductions from that, you're going to want to itemize specifically what deductions are going to be coming out of those settlements.
And Lesesne, you've also got the issue if you pay by percentage, then you have to put in there that the contractor is entitled to review your freight billing to make sure he's getting paid the adequate percentage.
Exactly. No, absolutely. And they do it for good reason. I mean, yeah, there sometimes where, that they want to make sure that they're actually getting the right percentage and not messing around with whatever rate confirmation that they got. So, some other provisions in here that are going to be, that you want to address in the agreement is workers' comp for the lessor's employees. So when I say lessor, that's the independent contractor that is leasing the agreement to the motor carrier. So how are you going to, because presumably, and you want the contractor to be able to use other individuals to drive their truck if they want to. So it's going to need to address that. Different types of insurance you could require them to either purchase, or if you pay for the insurance, you could deduct a percentage of the premium. One thing that needs to be in there is that the motor carrier is going to provide for the auto liability insurance. So that's going to be important to have.
Yeah, and that sometimes we get questions about, can you deduct? Can I make them pay for X, Y, or Z? Can I deduct that from their settlement? And Lesesne made me think about that when he's talking about auto liability. The answer is you can do pretty much whatever you want as long as you put it in the contract. You have to say it in the contract. So, for example, most carriers pay their own auto liability. They might make the IC pay for non-trucking, but they pay their own public liability. But some contractors charge back for that. We're going to charge you a prorated amount of what we pay for liability coverage. And there's actually a case where a court said you can do that. Even though it's your responsibility under the law to provide that insurance, you meet that responsibility when you buy it and provide it, but there's nothing that says you can't bill it back to the contractor, but you have to put it in the lease. So as long as, pretty much anything, as long as it's described in the lease, you can do. So just keep that in mind when you're thinking through that.
I'm just going to touch on escrow, and that's one of the most common mistakes, and you want to have escrow to, if the contractor ends up either damaging equipment or something like that, where, you can make sure that you're able to get paid if they leave you in the lurch and you have expenses. But the biggest thing with escrow is if there's interest on it, then you have to pay that contractor at least quarterly on that interest. And there's a specific, you have to, I can't remember, it has to be at least, I think it's a 91-day treasury bond. That's the minimum amount of interest that you have to pay them, and it has to be paid out at least quarterly. So if you have escrow accounts, then it can, you may be thinking, oh, well, I only have each driver. It's a small amount of escrow that I keep. Well, if you have a lot of drivers, then that can add up if you're not paying them interest on those escrow accounts.
Just because you don't call it escrow is still escrow. You can call it a maintenance fund, or you can call it something else. But if it's required, if you're requiring it, it's probably going to be deemed to be escrow.
That's right.
If your driver terminates the lease, and remember, if you're in this business of dealing with independent contractors, you've got to use the right language. If you're terminating, that relationship, you're not firing the driver. You're terminating the contract. And then if you don't like that driver, that his the safety record has gotten too bad, you could offer them a chance to substitute another driver on the lease. And so make sure that when you're thinking about the independent contractor relationship, that you're not thinking like employees, that you're realizing that this is a contractor. But if you terminate that relationship, you've only got 45 days to clear out that escrow. So that's something that people make a mistake on too, is that if you're gonna terminate that relationship, you've only got 45 days to clear out the escrow, and you're thinking, well, I'm not gonna know what he owes me, but I mean, it doesn't mean all the paperwork has to be settled. But if at the end of the day you're gonna owe that contractor some of the escrow, you need to at least pay what you're pretty sure you're gonna owe.
Absolutely. I'm going to skip through some of these slides so we can talk about. So, somebody can write the best contract in the world for you, but if you're not actually implementing it, then it's not going to save you. So, the biggest thing is you need to, if you have an independent contractor agreement, you need to look at the provisions in there and make sure you're implementing them. Just having it on paper and then doing something different is not going to help you. So here are just some general tips on individual or independent contractors. The last thing is wanted to touch base on. I think Rob talked about it a little bit. Is where the truck comes from. So we talked about lease purchases. Who provides the truck. So generally, if the driver owns it, they're an owner operator. That's going to be good. If the driver leases it from a Penske, that's also going to be good. If you're just providing it to the driver, you're throwing they show up and the independent contractor shows up and you're just throwing them the keys and saying, hey, take this truck that we got. It's not going to be good. A lot of times if the motor carrier itself, if they just lease it to the driver, it's not as good. But we can talk a little bit more. So that brings us to lease purchases. So Rob talked about the fact that you could have a separate leasing entity to lease it to the independent contractor, and then the independent contractor then turns around and leases it on to the motor carrier. So that's what this triangle is supposed to look at. So you're supposed to have two different leases here. One thing I will touch on with lease purchases real quick is they are under a little bit of scrutiny. So there's a sign that is want to get back on your feet, missed 2 car payments. One of the biggest scrutinies of lease purchase programs, and there was actually a study that was the FMCSA made a task force, and what they saw is that a lot of times the contractors were not they weren't actually being able to own the truck at the end of that lease purchase. So, it should be a good, entering into a lease purchase should benefit the driver because they're at the end of the lease purchase, they're actually going to be able to have a truck of their own. And so it's important to enter into that relationship, a lease purchase, with the right intentions. So, that's all that we had for that for today's presentation. I want to thank Fred for jumping on as well. So that was glad to have him.
And we will post this. We always post these to the website. I think usually within a week or so afterwards. So Lesesne had a lot of slides that we kind of went through quickly. So those will get put up on the website and you can go back and review that. Good stuff.
Well, people that got on probably were thinking about the Bateman, Batman, you need Batman, but you got Bateman thing when Fred showed up for me. But thank you, Fred. I appreciate you filling in most eloquently.
Well, the only thing that can keep you from our webinars is the judge. So the judge kept you out for the first 20 minutes, but glad to fill in.
Yeah.
Always a pleasure.
All right. Well, thank you all very much. Alex, anything else we need to tell them?
The only other thing is look out in your emails. We'll be sending out for our next webinar, which will probably be towards the end of November. So look in your emails for what's coming out.
Thanks,
All right.
everybody.
Thank you.